With that, Mr. McKeska, would you please begin the announcements?
Yes, Judge Drake McCaskill, attorney for the department.
Jennifer Simmons, family-based caseworker.
Carol McKetta, family-based supervisor.
Jennifer Harris, filling in to fill for Miss Colroy, the attorney for the mother. Ma'am, can you please unmute and announce your name?
I am unmuted, I think.
Yeah, you are.
Yeah, I'm unmuted.
So just say your name.
Laura Martinez, the mother.
Maureen Yanis, attorney ad litem for the children.
Anyone who's not an attorney? I'm sorry, go ahead. I think I forgot somebody.
Ashley Hartwick Smith, the Texas Family First Supervisor.
We were last here on, I think it was December the 10th. And at that time, there was compliance, but there were still a few issues between the couple, hotel stay, and Pat and TFF were completed, but we wanted another 30 days or so to see how things were going. Ms. Simmons, what is your opinion of where we stand in this case and where the department wants to go?
Since that last court hearing or the last incident where Laura stayed, Miss Martinez stayed in the hotel for that night, they've continued the couples counseling. They did an additional 7 to 8 counseling sessions. Miss Botero, their couples therapist, dismissed them as successful in the couples counseling. Ms. Martinez has also continued to go to Hill Country MHGD. She's set up with a counselor there to transition out of the CPS provided counselors, along with medications. Ms. Martinez has shown a lot of progress in the service that she's done and the amount of services she's done. So the department's comfortable with dismissing the case.
And are you saying dismissing completely or just dismissing from the court intervention?
We plan on closing the case after this court hearing and dismissing.
Completely. All right. Okay. Mr. McKeska, questions for Ms. Simmons?
None, Your Honor.
Ms. Harris?
Then
Ms. Yanis?
No questions, Judge.
What are your thoughts?
This couple, they were both extremely committed to this process, Judge. They went over and above. I know that every relationship is wrought with few, issues, but they've done everything that they were asked to do. They have complied and followed all the recommendations. Today, I think dismissal is appropriate at this time.
Yeah. With Ms. Simmons' testimony and the opinion of the ad litem court finds it's in the best interest of the children to dismiss this case and get it off the court's docket. And Ms. Martinez, it sounds like it's not only going to go off the court docket, but it's just going to be closed completely. So congratulations. Let's give a round of applause for working hard. It's a good day. I just want to remind you that life will continue. Things will continue. I don't want to see you back here, and I mean that the nicest way possible. So anytime you run into problems that you feel like the two of you can't figure out on your own, then you know what it's like to call a counselor and get some help. And you know that that's a valuable tool, or just to go talk to somebody else. You've learned tools in counseling and in your classes that help you deal with anger and emotions and things like that. So use those things and remember those things, and just remember more than anything that the children, they're depending on you to use those tools so that we don't have to wind up back here again and we don't have to deal with anything else happening that might be unfortunate. So just encourage you to reach out, and again, congratulations. And if nothing further, thank you all for your time and your service on this case, and all parties are excused.
Thank you, Judge.
Objection, Your Honor.
No
No.
objection.
No objection, Your Honor.
With that, Mr. McKeska, would you please begin the announcements?
Thank you, Judge Drake McKeska, attorney for the department. Mr. Tucci.
Alejandra Cerduche, permanency specialist with Belong.
Ashley Crouch, permanency supervisor with Belong.
Deborah Fuller, standing in for Irene Acosta, who represents Misty Pearson, Your Honor.
Kurt Rudkin, attorney for Father Roland Reyes.
David Nelson, CASA advocate for the children.
Jennifer Harris, attorney for respondent father, Mr. Moselle.
Cecilia Harang on behalf of the child.
Amy Harding, Hill Country CASA supervisor, guardian ad litem for the children.
Any housekeeping issues we need to take up?
Judge, I believe we've received the relinquishments that we were supposed to. And so we're ready to proceed today. Just as a precursory matter, if we could just go ahead and introduce the exhibits and get that out of the way, so we can streamline testimony.
Any objection?
No.
No
No.
objection.
No objection.
No.
All right, then with that, let's go ahead and list the exhibits, Mr. McKeska.
And yes, Judge, if the share screen function's enabled, I can broadcast them for everyone as well. So as petitioner's exhibit number 1, Judge, we have the mediated settlement agreement that was reached in this case on December 1st of 2023. It was filed with this court. As petitioner's exhibit number 2, we have the affidavit of voluntary relinquishment of parental rights for the respondent mother, Misty Pearson, that was filed with this court yesterday afternoon. Petitioner's number 3, Judge, is a executed affidavit of voluntary relinquishment of parental rights for Mr. Roland Eric Reyes Sr. That was filed with this court, I believe, on January 2nd or 3rd of 2024. Petitioner's 4 is a file stamp copy of the agreed temporary order following the adversary hearing in this case. Petitioner's 5, scroll to it, is a file stamp copy of the family plan of service for Mr. Jeffrey Moselle. It was filed with this court on September 14th of 2022. And then finally, petitioner 6 is a file stamp copy of the status hearing order from this case that was entered on September 14th of 2022. And with that, Judge, then I would like to call my first witness, which is Ms. Certucci.
Proceed.
Thank you, Judge. Ms. Certucci, will you please state your name for the record?
Alejandra Cerduche.
And how are you currently employed?
I'm a permanency specialist with Belong.
And are you the permanency specialist that's assigned to this case?
Yes, I am.
Okay. And how long have you been the permanency specialist for this case?
Since March of 2023.
Okay. And once you became the permanency specialist for the case, did you review the case file?
Yes, I did.
Okay. Are you familiar with the documents that were prepared for this case prior to becoming the primary caseworker?
Yes.
Okay. On December 1st of 2023, the parties attended mediation. Is that correct?
That's correct.
And we were able to reach an agreement with the parties during mediation?
Yes.
Okay. And I just want to hit the highlights of the MSA. Do the parties agree to seek termination of respondent father Jeffrey Moselle's rights today based solely on the O-ground in his failure, and best interest of Christian?
Yes.
Okay. Do the parties also agree that the department would seek termination of Mr. Reyes's parental rights to his son, Roland Jr., based off a relinquishment of parental rights?
Yes.
And we also agreed that for Eric Jr., or Roland Jr., sorry, that we would continue to make efforts or best efforts to achieve permanency by relative adoption with his current placement, Miss Haley Reyes.
That's correct.
Okay, and that there's an agreement that Miss Pearson's rights will also be terminated based solely on a voluntary relinquishment to the 2 remaining children.
That's correct.
Okay. There's also an agreement that Miss Pearson will have monthly contact with Christian for an hour, provided that Miss Pearson travels to the location, the visit location, and so long as those visits remain in his best interest.
That's correct.
Okay, and then the final agreement that was made was that the department would study Mr. Robert Hoseman as potential placement for Christian. Is that correct?
That's correct.
Okay. And that's still the department's plan today, is to follow that agreement?
Yes, sir.
Okay. I should have just kept the share screen up. I'm going to show you what's already been admitted as petitioners to, which is a copy of Miss Pearson's voluntary relinquishment. Do you see that on the screen?
Yes, I do.
Okay. And at the time that Miss Pearson executed this voluntary relinquishment, was she represented by an attorney?
Yes.
And did Miss Pearson have the opportunity to review this document with her attorney?
Yes.
Is it your understanding that Miss Pearson was able to ask her attorney any sort of clarifying questions so she understood exactly what she was signing?
Yes.
Okay. Did the department make any promises to Miss Pearson in exchange for her relinquishment?
No.
Did the department threaten Miss Pearson in any way in exchange for her relinquishment?
No.
Is it your understanding that Miss Pearson executed this relinquishment freely and voluntarily?
Yes.
Okay, and that she did so believing that it was in Christian and Roland Jr.'s best interest?
Yes.
Okay, when Miss Pearson executed this relinquishment, did she do so in front of 2 witnesses?
That's my understanding. Yes.
Okay, and she also signed in front of a notary for the state of Texas?
Yes.
Okay. And prior to the relinquishment being filed, you weren't able to sign as consent for the department to be designated as the managing conservator, did you?
No.
Okay, but today, for trial, are you consenting to that designation?
Yes.
Okay. Do you believe that determination of the parent-child relationship between Ms. Pearson and the 2 children that remain in this case is in the children's best interest?
Yes, I do.
And can you briefly explain for the court why you believe that termination of that relationship is in their best interest?
We've been trying to get Christian, well, firstly, with Roland and Haley, he'd be with family. So that's a permanent option for him. And he's not really bonded to his mother at this point in time. So it would be in his best interest to remain with Miss Reyes. And with Christian, we've been having difficult times finding reasons to have him with Miss Pearson, and based on our concerns that we had while he was placed with her for that monitored return, we just believe it's in his best interest to move forward with adoption for Christian.
Okay. And with Roland Jr., the permanency plan currently is relative adoption, correct?
That's correct.
Are there any current barriers to being able to achieve that permanency goal after today?
No.
Okay. Is the home licensed?
Yes.
Okay. And has Miss Reyes expressed a desire to adopt Roland Jr.?
Yes.
Okay. With regard to Mr. Eric Reyes Sr., he also executed an affidavit of voluntary relinquishment that's been admitted as petitioner's exhibit number 3, correct?
Correct.
Okay. At the time that Mr. Reyes executed his affidavit, was he represented by an attorney?
That is my understanding, yes.
Okay. And did Mr. Reyes have the opportunity to review this document with his attorney?
Yes.
Is it your understanding that Mr. Reyes was able to ask his attorney questions and understood what he was signing whenever he executed this relinquishment?
Yes.
Did the department threaten Mr. Reyes in any way, shape, or form in exchange for his relinquishment?
No.
Did the department promise Mr. Reyes anything in exchange for his relinquishment?
No.
So you're understanding that he signed this relinquishment freely and voluntarily?
Yes.
and that he did so believing that it was in the best interest of his son.
Yes.
Okay. Are you asking the court to terminate the relationship between, or sorry, let me back up. At the time that Mr. Reyes executed this relinquishment, did he do so in front of 2 witnesses?
Yes.
And did he also execute it in front of a notary for the state of Texas?
Yes.
Okay. And at this time, Mr. Reyes is also currently incarcerated with the Texas Department of Criminal Justice, correct?
That's correct.
Okay. Are you asking the court to terminate the relationship between Mr. Reyes and his son based solely off this affidavit today?
Yes.
And do you believe that termination is in Roland Jr.'s best interest?
Yes, I do.
Okay, can you briefly explain why you believe that termination of the parent-child relationship between Mr. Reyes and his son is in Roland Jr.'s best interest?
Mr. Reyes has not had a relationship with Roland. He's been incarcerated and he has a release date projected for 2030, I believe. So for permanency, that would be the best thing for Roland to be with Ms. Reyes.
Okay. Finally, with regard to Mr. Moselle, there's an agreement that we would seek termination based solely off of his failure to complete services. Is that correct?
Yes.
Okay. Do you recall why were the circumstances under which the children were removed from Miss Pearson?
Yes, neglectful supervision.
Okay. What were the exact circumstances that led to removal? Do you recall?
It's leaving my mind, but I remember reading about Roland falling off of the bed and getting hurt. They were left unattended.
Okay. And was it the department's understanding that Ms. Pearson was present whenever he fell off that bed?
I don't believe she was present.
Okay. And following or at the time of removal, Mr. Moselle was incarcerated, correct?
That's correct.
Okay. And during or at least at the beginning of this case, he was an alleged father for Christian.
Right. Yes.
And during the course of this case, the department completed genetic testing between Mr. Moselle and Christian, correct?
Yes.
And after that genetic testing, Mr. Moselle was adjudicated as Christian's father?
Yes.
Okay. After the removal of Christian, did the department create a family plan of service for Mr. Moselle?
Yes.
Okay. And do you recall what specific services were on that family plan?
Yes. He had paternity, he had parenting, a psychosocial assessment, and individual counseling. Okay.
And was Mr. Moselle able to complete any of those services while he's incarcerated?
He was not.
Okay. Were you able to check with the facility to see whether or not any of those services were offered?
We were trying to contact through the facility. I tried to visit with him in person, but they were adamant that they would not allow me to see or speak with him.
Okay. Have you had communication with Mr. Moselle?
Just through documents, and we had, I believe, one phone call that was between him and my supervisor and Miss Bainbridge.
Okay. And did Mr. Moselle know and understand that he had a family plan of service in this case?
Yes, it was mailed to him as well.
Okay. And he understood what was expected of him in order for him to be able to complete that family plan?
Yes.
Okay. Following the completion of, or the development of the family plan of service, was the family plan made in order of the court?
Yes,
Okay, and so Mr. Moselle was ordered to be able to complete these services, correct?
that's correct.
Okay, and it's your testimony today that he's been unable to participate in any of these services due to his incarceration?
Yes.
Okay. Do you believe that termination of the parent-child relationship between Christian and Mr. Moselle is in Christian's best interest?
Yes, I do.
Okay, and just can you briefly explain for us why you believe it's in his best interest?
They do not have a relationship currently. They don't have a bond, a father-son bond, and I believe Mr. Moselle has expressed that he did not want anything to do with Christian.
Okay. What is the permanency goal for Christian at this time?
Unrelated adoption.
And are there any prospective placements at this time?
There is an active placement search on Christian, but with the rights of his mother and father still intact, we've had those barriers.
Okay. Pass the witness, Your Honor.
This, Ms. Harris, you'd be first since Ms. Acosta's not here.
I'm standing in for Ms. Acosta, Your Honor.
Ms. Fuller, I'm sorry.
I just had one question. Based on the MSA, was there an individual that the department or Belong was going to be looking at for placement of Christian?
We did attempt a home study request on an individual that Miss Pearson named. The contractor has made multiple attempts to reach him, and Miss Pearson confirmed his phone number was correct. He just has not gotten back to the contracting agency for the home study, so it has not been done.
But Belong will still pursue that based on the agreement of the MSA.
Yes, ma'am.
And you feel that the department has done everything in their power to attempt to reunify the children with Miss Pearson?
Yes, I do.
And you feel it's in the best interest to terminate her rights so the children can be adopted?
Yes, I do.
I'll pass the witness, Your Honor.
Ms. Harris.
Do you have an expected release date for Mr. Mizell?
I believe the projected is 2038.
No further questions, Judge.
Mr. Redkin?
Just a couple. So the child, Roland, being adopted by my client, Roland Eric Reyes' daughter, is that correct?
That's correct.
And the child has been with her for quite some time, is that right?
Yes.
And all the communication that Mr. Reyes, my client, has had with the department, caseworkers, and everybody involved with the department in this case, has been that he is okay with his daughter adopting the child. Is that right?
Yes, sir.
That's what he's wanted from basically day one. Is that correct?
Yes.
And that's what's getting ready to happen, or that's what the plan is, correct?
Yes,
You believe that that's in the child's best interest, of course, right?
I do.
No other questions.
Ms. Alro?
Yes, with Ms. Pearson, have you been able to have any visits with Christian and Ms. Pearson since the last hearing?
I have not. The last visit I had with both of them was the weekend before Christmas, so December 22nd.
How did that go?
It was good. They were sitting there. She gave him his Christmas gift. We were at McDonald's. They were playing on a tablet that she had gotten him for Christmas. There was a gingerbread house that they were supposed to build, but they never got around to it because he was too into the tablet.
Do you still believe that ongoing visits once a month, supervisor, still in Christian's best interest?
I do at this time, yes.
What is the permanency plan for him?
Unrelated adoption.
He's currently at a shelter in Kerrville, is that correct?
Yes.
Okay. Have there been any options for placement for him recently?
Not that have come to us, no.
Will the Belong continue to search for any family and or fictive kin for him as a potential placement?
Yes.
He had I don't know whether this was prior to the last hearing, but he has been diagnosed as having an intellectual disability, correct?
Correct.
So any placement for him is going to have to be specialized and catered specifically to his needs. Is that correct?
Yes, ma'am.
Okay. Mr. Mosel is currently incarcerated for aggravated child. Is that correct?
Yes, ma'am.
So even if he were released, it would be unlikely that he would be permitted to have Christian in his care, correct?
Correct.
Christian has a bond with his mother, pretty strong bond. Can you explain to the court why it is still in his best interest for mom's rights to be terminated at this time?
During the monitored return, we had various concerns with Miss Pearson's ability to care and protect Christian. There were allegations of some possible abuse from an individual that Miss Pearson has history with. That Christian made an outcry to Miss Harding initially. And then he was getting sick all the time. He was missing school frequently. So it was very concerning for us, her ability to be a parent to Christian in a way that was effective to him and his needs.
So despite the bond, she's not capable of parenting this child. Is that correct?
That's correct.
Nothing further at this point. Thank you.
Any follow-up?
No, Judge.
I'm sorry?
Not from the department, Judge.
Okay. Any other witnesses?
No, Judge, with that, the department rests.
Anybody else have a witness to call?
No
No
witnesses.
witnesses.
No.
All right. Any other evidence presented at all?
No, Judge.
Okay, then with that, Ms. Hillrum.
Your Honor, I believe that termination of parental rights of all three parents is in the best interest of the children. Roland Jr. has been with Ms. Reyes the entire case. He is very bonded. I have had the opportunity to observe a visit with Mom and Roland, and I do agree with Ms. Ortucci that there really is no bond. The facts leading to removal in this case were pretty significant. Ms. Pearson did plead guilty to endangering the children. As you know, there was a previous case where there was reunification. Removal was within 6 months after reunification. My concern with Ms. Pearson is that she loves her children, but is completely incapable of parenting them. We did attempt a reunification with Christian and Ms. Pearson, and she was going from motel to motel. She was very rarely with Christian, and when she was with Christian, it was not appropriate. Christian did make an outcry that one of Ms. Pearson's paramours did use him, and we did have to do a removal pretty soon after the reunification attempt. Christian is complicated. He has a lot of needs. He is a very sweet boy. If he could stay at his current placement, they love him. But we do know that we have to move forward. It is going to be extraordinarily difficult to move forward, especially if the parents still have their parental rights. Mr. Mosel has been incarcerated since the last case. He was convicted in 2013 for assault on a child. And so he has never had any contact with the children and with Christian since I have been involved in this case. I do not know what his intentions are, but even if he were to be released, it is unlikely that he would be appropriate for the child. I do believe that adoption by Ms. Reyes of Roland is in Roland's best interest. He's there. He's been there the whole case. He's very, very bonded. So I think that is going to end in permanency. We don't know yet what's going on or what's going to happen with Christian, but I do believe that all of the legal team is aligned in what we believe is best for Christian. And at this time, it is termination. Thank you.
Awesome.
Yeah, it's no doubt to me that Roland Jr. is very happy with Haley. He has an excellent relationship with Haley and that family. It's a good placement, and ultimately, it will lead to adoption. Will lead to a life that Roland deserves. As far as Christian, there are some, as Ms. Hellrung had said, there are issues with Christian as far as just his education. He's got some health issues. and things like that. But where he is right now is good. K-Star takes very good care of him, but yeah, it is not a permanent situation. But going back to the situation with his mom, that's just, she's been given many chances and it just doesn't work. It's not something that can be full, it's just something that's not going to work. So we feel that removing her custody, removing her as a parent gives us an opportunity to find the right answer for a Christian.
Thank you, Mr. Nelson. Ms. Sototuche, what did you testify? This is the one thing I can't remember as to the permanency goal for Christian. Was it adoption?
Unrelated adoption.
All right. That's what I thought, but I just didn't want to make that assumption. Okay. And before I make any orders, because we have an MSA in this case, I'm assuming because there were no objections to the exhibit, that there was no issue with the MSA as it was in the agreements of the parties, correct?
Correct, Your Honor.
Correct, Your Honor.
Yeah, correct.
Thank you. Then, based on the testimony and arguments of counsel and the agreement of the parties, court finds that it has jurisdiction over the subject matter in this suit and the parties of this suit. Court finds that it has continuing exclusive jurisdiction of this suit and that no other evidence of any other court having exclusive jurisdiction has been presented. Court finds that all parties entitled to citation and notice were either cited and served or appeared in this matter. And court finds that the MSA of the parties, the settlement agreement, is in the best interest of the children, and the court will adopt and approve that agreement as stated. Pursuant to that agreement, court finds that the department has proved by clear and convincing evidence as to the father, Jeffrey Mosel, under 161.001B10, that Mr. Mosel failed to comply with the provisions of a court order that specifically established the actions necessary for the parent to obtain the return of the child who has been in the permanent or temporary managing conservatorship of the Department of Family and Protective Services for not less than 9 months as a result of the child's removal from the parent under 262 for the abuse or neglect of the child. Court finds that the department has proved by clear and convincing evidence pursuant to Chapter 161.001B1K that the mother, Misty Pearson, and the father, Roland Reyes, have each executed before or after the suit was filed an unrevoked or irrevocable affidavit of relinquishment of parental rights. And the court finds that for all three parents, termination of their parental rights pursuant to those grounds is in the best interest of the children. Court will name the Department of Family and Protective Services as the permanent managing conservator of both children. Court finds that the permanency goals of adoption are appropriate in the best interest of the children. Court finds that their placements are safe, appropriate, meeting their needs, and in their best interest to continue. Court finds that the parent or the attorneys for the parents, Mr. Rudkin and Ms. Harris and Ms. Acosta, have all satisfactorily performed their duties, and the court will dismiss them from this case. Court will maintain Ms. Hellrung and Hill Country Casa's appointments as guardian ad litem and attorney ad litem in this suit. Court sets a permanency hearing after final order for April the 3rd, 2024 at 11:30 a.m. Anything I failed to address?
I believe you covered it all, Judge.
Well, thank you all for your time and your service on this case. We've worked with this family for a long time. We've had lots of hearings in this case and others, and I appreciate everybody's hard work getting us to this point and being able to come to an agreement and expedite things. So I will see some of you on April the 3rd at 11:30. The rest of you, thank you for your time and your service. I think further, all parties are excused.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Today. You're welcome, sir.